minutes for you. With that being said, we are ready to begin. The first case today is Almost Family, and no nurses on call.
Good morning, Your Honors. If it pleases the Court, Patrick Muldowney on behalf of the appellants, Almost Family, Inc., and Care Tenders Visiting Services of Pinellas County, LLC, which we may refer to as Care Tenders. Your Honor, I'd like to reserve 5 minutes of time
Thank you.
for rebuttal. Your Honor, in the instant action, the appellants have sued the appellees, sued the appellee Michelle Sprow for breach of contract with respect to a non-compete agreement that she had signed in connection with her employment by my clients. They also have sued the appellee nurse on call, who I may refer to as NOC, for tortious interference with respect to its employment of Ms. Sprow in knowing disregard of her non-compete agreement. And lastly, we've sued Ms. Sprow and NOC for tortious interference with respect to their unlawful disruption of the appellant's advantageous business relationships with referring physicians. The trial court had granted summary judgment to the on appellee's motion for summary judgment. In a one-paragraph order, the court stated that, quote, the case of Florida Hematology and Oncology versus Tamala is controlling to the extent that the 5th DCA, held referral source relationships, are not a legitimate business interest under Section 542 of the Florida statutes, and that the reason, that for this reason and reasons stated at the hearing, the summary judgment was appropriate. We would argue, Your Honor, with all due respect to the trial court, that the granting of summary judgment was an error for 3 reasons. One is the court refused to find that referral sources are protectable, and that we believe is contrary to the law of Kentucky, which under the contract is the law that's deemed to be controlling, and the law of Florida, Your Honor. Secondly, we would argue that the court ignored the legitimate business interests of confidential information and unique and specialized training that was proffered by the appellants. At the very least, we believe there's an issue of fact, a material issue of fact, that would preclude summary judgment. And third, based upon the improper dismissal with respect to the contract claim, that the tortious interference claims were improperly dismissed as well. Let me just sort of, from factual perspective, I'm sure Your Honors have reviewed this, but there are certain facts that are beyond dispute. First of all, Ms. Sprow was employed by the appellants as an account executive, and as an account executive, her job was mainly to market the appellants to healthcare providers and institutions that would refer patients to the appellants.
Is there anything in the record that shows how much she got paid for doing this account executive job?
Your Honor, I believe, I'm not sure if there's actually anything specifically in the record, but she was paid a salary. It wasn't a commission-based process, but she received a significant salary. I mean, it was not 6 figures, but it was certainly above 30. I believe it was somewhere in the mid 5 figures. And in connection with her employment by the appellants, she signed a non-compete agreement under which she agreed she would not work for a competitor in the county in which she was working, in this situation, Hillsborough County. She would not for a year, nor would she solicit any of the appellant's customers or clients, or discuss with the appellant's employees leaving appellant's employment for a period of 1 year. Ms. Sprow left the appellant's employment and immediately went to work for NOC. It's beyond dispute that NOC and the appellants are direct competitors in the home health care industry, including in Hillsborough County. And regarding her employment by NOC, Ms. Sprow's duties were the same, and the clientele essentially were the same as they were during her employment by my clients. She works for NOC in the same territory she worked on for the appellants, calling on many of the same physicians and healthcare providers. The appellees don't dispute that the non-compete agreement, in terms of its restrictions, in terms of geography, and in terms of time, and in terms of line of business, are unreasonable. So we don't have that issue here. And they also don't dispute that she breached the agreement by, in fact, going to see referral sources and competing against my clients in Hillsborough County. What they do obviously dispute is whether there's a legitimate business interest protected here under Florida law. Now, again, we argue that the first place you all should look at, and the first place the trial court should have looked at, is Kentucky. The non-compete agreement states at paragraph 12 that the agreement shall in all respects be interpreted, enforced, and governed under the laws of the Commonwealth of Kentucky. Now, we cited some case law to you in our briefs, in both our initial brief and in our reply brief. In Kentucky, a non-compete agreement is enforced as reasonable if, on consideration and circumstances of the particular case, the restriction is such only so as to afford fair protection as to the interests of the covenantee, and is not so large as to interfere with public interests or impose undue hardship on the party restricted. That's out of the Central Adjustment Bureau case, 622 Southwest 2nd, 681. Cases we cited, including that case talked about the fact that a covenant not to compete should be enforced so as to prevent a plaintiff from taking employees, prevent employees from resigning and attempting to pirate away the clients and business relationships after the employer has expended effort, time, and money in training.
Was the issue in Central whether or not a non-compete clause contract signed after employment was valid? Was that the issue in that case?
I believe that's so, Your Honor. But again, the general principle is that they enforce these matters. It is enforced if there's a reasonable business interest being protected, and it's not, and the restriction itself is not so unreasonable as to impact on the public interest or on the individual it's being enforced against. The other cases we cite include the Hammonds versus Big Sandy Claim Service case, which enforced a non-compete agreement to protect an employer from an employee, a former employee, undermining its relationships with its clientele. Now, I know the appellees mentioned in their brief that we allegedly had said that the law in Kentucky and Florida are the same. Your Honor, we did not say that. I believe if you look at the hearing, if you look at the record below, and you look at our briefs, what we were saying was Kentucky does not specifically address the issue of referral sources. I mean, they do not have a case that we found, and I don't believe my esteemed opponent found any case either where it talks referral sources are not protected or are protected. But if you look at the law of Kentucky, the law of Kentucky talks about business interests, protecting legitimate business interests, and talking about, is the non-compete necessary for that interest? If you look at various courts, including the Middle District of Florida in the Electrostim case, which we cited in our brief, the Electrostim case talks about plaintiffs, customers, or clients within the contemplation of that restrictive covenant included doctors and other clinicians who were basically referral sources. The Electrostim case involved durable medical equipment salesmen. Very much, we believe, the similar situation as our marketing representatives, the account executives, that these individuals would go to doctors and help and market to doctors with the hope that the doctors would use their products, their services, in connection with their patients. So I mean, the doctors are not the end users, but the relationship is very important because the doctors are the ones who would basically either use the DMS or in our situation would refer patients for home health services.
Well, what about the other side's argument that everybody knows who the referral sources are? There's no secret or any particular ownership of these people, and they can't be paid any kind of a consideration for making the referral. So where's the business interest with respect to those people then?
Well, I think, Your Honor, we would take exception with the idea that while people know who the doctors are, what the doctors' preferences are, how the doctors want to be marketed, individual specific idiosyncrasies about the doctors and their practices. Those are things that are not publicly available, and those are things that are developed over time by going and seeing the doctor, getting to know the doctor, building the relationship with the doctor. That information is not publicly, I would say, it's not publicly available without pushing and trying for it. It's not like you can open up a book and find all that kind of
What's
information.
an example of a particular preference or idiosyncrasy of a doctor that would make a difference in this business?
Well, I think in terms of how they want to be approached, what their, in terms of what the preferences are of the person who may in their office may make the decision. Sometimes in a lot of these places, the doctor is not the decision maker in terms of referring. It may be a nurse in the practice. It may be a physician's assistant. Those kinds of idiosyncrasies, things about what the doctor wants for their patients in terms of how they want their patients approached, how they want them treated. Those are things that are not in a book. And you can go to the yellow page, or you could go to the medical practice directories and find that information in terms of who's in that location. But what those people, how those offices operate, what annoys a doctor. You don't want to go in there and do something that's going to annoy the doctor and not necessarily, and which may in fact hurt your business. So those kinds of things in terms of what the doctor prefers, in terms of how you approach him, or her, I should say, how you approach the patients, the types of, who the real decision makers are in the office, who are the people you need to develop the relationship with in that office. Those are all things that are not publicly available, as opposed to information about who they may, how many people they may have referred to whom a year ago. What you need to know is what's going on at that point in time in terms of the development of that relationship. If you look at the testimony that was produced in the record from the CEO of Nurse on Call, I mean, he actually did say that they put together information concerning doctors and referral sources. And then when I asked him about, well, could I see that? He said it's confidential, which is exactly what we're trying to say here. Now, he tried to walk it back later in the deposition, and I know the appellates had mentioned that in their brief, but before he realized that, gee, I may have stepped in this, he said, this is confidential. The information about the specific referral sources are the kinds of things that you develop in that contact between the account executive and the referral source. The third DCA in the Nieves-Garcia matter looked at that type of information as being protectable as well. We would argue that, Your Honor, that if you look at Kentucky law, that if you look at the Electrostim case, you look at the WellSpan case, which is out of Pennsylvania, they recognize that these business relationships, that these referral sources are business relationships. Even the Tamala case, which the appellees rely upon, states specifically, the court acknowledges that the referral sources at issue in that case, quote, are perhaps appellant's most crucial business interests, close quote. As the Kentucky courts have stated in both the Central Adjustment Bureau and the Hammonds case, protecting business relationships from being pirated away by a former employee is a legitimate business interest that may be protected by a non-compete. And that should be enforced under Kentucky law. We believe the trial court improperly failed to do that, and thus the trial court's grant of summary judgment was an error and should be reversed. Even if you looked under Florida law, though, Your Honor, there is, while they have the Tamala case, we would argue with all due respect to the 5th DCA that's an incorrect decision. That when you look at, first of all, the 3rd DCA in the Torre Grossa case did reference the fact that the referral sources were in fact protectable interests. The Supreme Court eventually in the Tamala case took it up initially on a conflict between the 5th and the 3rd, then backed away from that and dismissed it for lack of jurisdiction, which provoked, as you may have seen from the case law, a rather vigorous dissent from, I believe it was Chief Justice Lewis, talking about how this was really a conflict, that we had a situation here where you have one district that says, as part of the decision to enforce a non-compete, that those referral sources were protectable interests. And then you had the 5th DCA finding that the referral source was not protected. They based it on what we would argue was an overzealous bootstrapping of the Sanal case, which in the first DCA had found that non-identified prospective patients were not protectable. So the Fifth DCA said, well, if that's the case, then referral sources are not protectable because they're a gateway to that. But we would argue that's not the analysis. The analysis here is the referral sources are an existing, ongoing, identifiable relationship. It's a business relationship. It's a relationship that our client and others in the industry expend a lot of time and effort developing. I mean, our client and others in the industry hire these kinds of marketing people to go and see these folks. Thank you.
It's your time.
Okay, no, I appreciate it. But I just wanted to argue, even under Florida law, we would argue that the Tamala case is wrong, is incorrectly decided. We would also point you to, as we did in the brief, the Supreme Court's, the U.S. Supreme Court's decision in the SmithKline-Glaxo case, the Christopher case. That's an FLSA decision, and understandably, it's not controlling on the court in terms of 542.335. But, Your Honor, we would argue that if you look at that decision, even though it's in the FLSA, they found that was a sales relationship. Even though it was a pharmaceutical rep, even though the pharmaceutical rep was marketing to a doctor who was not the end user, who didn't buy the product, because they referred and wrote prescriptions, that was seen as being a sales relationship, an identifiable sales relationship, and therefore under the FLSA, these individuals were salespeople, outside salespeople. We would argue the same thing here, Your Honor, that when you look under 542.335, that this is an identifiable sales relationship that should be protected. I understand my time has kind of come to an end. At least I'd like to keep the reserved time. But we would argue also, we would refer you to our brief with respect to the issues involving training and confidential information. And we would argue that on the basis of what we've argued in the brief and today, that the court reverse the trial court and send it back for further proceedings. Thank you.
Good morning, Your Honors. May it please the court, my name is David Potter. I'm here on behalf of the appellees, Nurse on Call, and Michelle Sprow. This case is about the enforceability of a general non-compete agreement against an entry-level marketing employee within the home health care industry. The court should affirm the trial court's final judgment because the appellees failed to establish a legitimate business interest for the enforcement of this general non-compete agreement. And what you've heard today and what the appellants are seeking to ask this court to do and what it asked the trial court to do is to find that relationships with these referral sources can constitute a substantial relationship. And I want to go through, before I talk about the non-compete statute in Florida, I want to go through some of the background legal principles that govern this industry, because this is a unique industry. This is not simply a case about selling widgets. This is the healthcare industry. We're dealing with patients. We're dealing with healthcare. And there are laws which prevent home health companies like care tenders, like Nurse on Call, from having substantial relationships with referral sources. Under both Florida law and under federal law, you can't have exclusive contractual arrangements with these referral sources. There are fines for physicians if they have them. You can't have a substantial investment of money in these referral sources. Under federal law, non-monetary gifts are capped at a few $100s per year. Monetary gifts are capped at $29 per year. So you can't have a substantial investment in wining and dining or doing anything else with respect to these referral sources. It would violate the law. Hospitals and surgical centers can't require their physicians to refer patients to home health agencies that those companies have an interest in. Home health agencies can't provide nurses and other professionals free of charge to get referrals. There can't be any sort of kickback or remuneration of any sort to attempt to get these referral sources to refer patients to you. The controlling factor in this industry is patient choice. The patients have the absolute right to decide who they want to provide care to them in the home setting. And if they tell someone at a hospital, a surgical center, or anywhere else that they want X company to do it, then that's what happens. And so there can't be under these background, both state and federal legal principles, there can't be substantial relationships with referral sources. Now, with that backdrop, I do want to talk about the Florida non-compete statute. And I think, as we all know, to enforce a general non-compete agreement under Florida law, you have to plead and prove the existence of a legitimate business interest. And the one that we're talking about mostly here today is substantial relationships with specific prospective or existing customers, patients, or clients. And there's a couple of words in there that I think are very important. One is substantial, which we've talked about some already, but the other is specific. It's not just any prospective customer, it's a specific prospective customer. Now, under the plain language of that portion of the statute, it doesn't say anything about referral sources. There's no specific protection for referral sources in the statute.
Are they considered in the nature of a customer?
Well, one could argue that they're in the nature of a customer, yes, but we'd suggest that they're different than a customer, and especially different than a customer in this industry, because a customer has that buy-sell relationship. That doesn't exist with referral sources, and it can't exist. So when they say that we admit that we violated the agreement by Ms. Sprow coming to work for us and soliciting referral sources, I think that's probably respectfully an overstatement, in that the agreement doesn't say anything about referral sources. The agreement talks about customers and clients. Now, they use that as shorthand for referral sources, but we'd suggest that it's very different, especially in this industry. Now, the decision of the trial court in this case obviously followed the Tamala case from the 5th DCA. And that case is consistent with the principles that I've been talking about so far, and certainly...
Let's just clarify for me, because the judge cited that case, but then also said, and for the reasons set forth in the hearing. Were the reasons set forth in the hearing different from the holding of Tamala?
If you look at the hearing transcript on the whole, I believe the answer is yes, and I'll explain what I mean in a moment. If you're looking for, was there a portion of the hearing where he said, here are all of my reasons, and it was more than what was stated in that order, probably not. But I think a fair reading of that transcript addresses some of the issues that Mr. Muldowney has brought up in terms of confidential information and training. And maybe I'll talk about those a little bit right now while we're talking about that point, because obviously the appellants take the position that the trial court erred by not specifically addressing confidential information and not specifically addressing training in his order. And we'd suggest that that's not well-founded for a few reasons. First of all, if the relationship with referral sources is not protected for the reasons that I've talked about, for the reasons that we see in the Tamala case, then information about those referral sources and training with respect to those referral sources also can't be protected. And this case really is all about the referral sources. And when you look at the confidential information and the training that they've alleged, and I believe that they acknowledge as much in their reply brief, and in footnote 5 of their reply brief, in part, they say the intent behind the non-compete agreement is to protect the appellant's investment in 1, developing and maintaining relationships with specific referral sources, 2, compiling valuable business information about those referral sources, and 3, training its marketing representatives and equipping them with appellant's business information, the business information about the referral sources. And so if the relationship can't be protected, information about the referral sources can't be protected, and training with respect to those referral sources can't be protected. And so the trial court asked appellant's counsel at the hearing whether, if he determined that Tamala applied and that referral sources were not a protectable interest, would that dispose of all of the claims? And Mr. Muldowney, I believe, answered yes, it would. And I believe that what that recognizes is that although it's been cast as 3 separate interests, it's really one interest. And if the court found that Tamala applied and found that the relationship with referral sources was not protectable, then the other interests also are not legitimate business interests that can be protected as well. Now, even setting that aside, if you look at the evidence about training and the evidence about confidential information, I'd suggest that the evidence on summary judgment showed that those were not legitimate interests that the court should have recognized. With respect to the training, I mean, as we know, it's not just any training that qualifies as a legitimate business interest. It's extraordinary training. It's something that goes beyond normal, ordinary, customary training. And the evidence on summary judgment was undisputed that the training that Ms. Sprow received at Care Tenders was training that was given to all marketing representatives at Care Tenders. It was training that was given to almost all employees at Care Tenders, period. It's also undisputed on the record below that the training that Ms. Sprow received at Care Tenders is very similar to the training that all marketing representatives get at all of these home health care companies. And part of that goes to the issue that was discussed a little bit ago about the fact that there really is not much that's confidential in this industry. And I want to talk a little bit about the exchange before about whether these lists in some way can be confidential, because the information in this industry is not confidential. Who gets these referrals? The market share of these various companies is publicly available information. Up until 2010, it was on a federal government website. It's not on there anymore, but since that time, you can purchase it from private companies, and that's what these home health companies do. They buy that data to see who's getting the referral sources. The identity of the referral sources is clearly not confidential information. It's on the Medicare website. It's on the internet. It's no secret if you're in the home health industry who you're targeting. You're targeting mostly elderly people who are on Medicare, because that is who is paying for the services. And so you can figure out who the doctors are that are going to be referring those sorts of patients for home health. It's not going to be the OBGYNs. It's not going to be the pediatricians. So you can look online, you can look in the yellow pages, or you just have feet on the ground where you find this information out. But they've admitted below, the appellants have admitted that the identity of referral sources is not confidential. Now, with respect to Mr. Clift's testimony, Mr. Clift is the CEO of Nurse on Call. He was deposed in a case in which Nurse on Call was not a party, and he was asked questions about the process by which he compiles his list. And it would probably be helpful just to say what he said briefly. When he was initially asked how is the list compiled, he did answer, as Mr. Muldowney said, I'm going to say it's confidential how we compile our list. Questions continued. He was then asked, but I'm saying again, how you put together this list you consider to be something that's confidential to Nurse on Call. Answer, I'll back off my statement. How we put together, and then he goes on to tell them. He didn't ultimately say that was confidential information, and he told them how they put together that list. But the things that we heard today, Mr. Muldowney said, is not confidential information in terms of how folks like their patients to be treated. That's information that any marketing representative can walk into any office and talk to those folks at the front desk, the discharge planners, and get that information. And the evidence below is undisputed that Nurse on Call had already been in this market, which was Hillsborough County, for 5 years before Care Tenders was. They'd already been getting referrals from these same referral sources. Their representative admitted at her deposition that there's no evidence that Ms. Sprow took with her any sort of list of these referral sources with all of this alleged confidential information, or that she was using a list like that in some way. In fact, the appellants admitted below that with respect to confidential information that they have no evidence that Ms. Sprow took anything with her, was using anything specific that they were complaining about, and in fact acknowledged that the confidentiality provision that's contained in the non-compete agreement, that provision itself would protect any interest they might have in confidential information, but it wouldn't support the enforcement of a general non-compete agreement. There was some discussion about Kentucky law and whether that applies. Respectfully to Mr. Muldowney, I believe he did acknowledge at the summary judgment hearing that the law of Kentucky and the law of Florida is not different. And he acknowledged that there's no specific case that addresses referral sources, but if you look at Kentucky law and how it goes about deciding whether to enforce non-compete agreements, Kentucky law looks at many of the same things that Florida law looks at. It looks at whether there is some interest that's being protected, an interest of the employer. It looks at the public interest with respect to that particular non-compete agreement. But also importantly, in many ways, Kentucky is more favorable to employees than what Florida law would be, because under Kentucky law, you can specifically consider whether there's an undue hardship to the employee who has signed that agreement and committed to do or not do certain things. And so if anything, Kentucky law is more favorable. But the trial court asked a couple of times, and in the end, the last question even said, I believe that Mr. Muldowney has acknowledged that they're not different. They're not different. And there's nothing under Kentucky law that indicates that this case would come out any differently under Kentucky law than it would under Florida law. So in the absence of any authority that shows it would come out different, it's really sort of a red herring to suggest that Kentucky law applies, and it was error to not recognize that and apply Kentucky law. With respect to the tortious interference claims, to prevail in those claims, the appellants would have to show some sort of relationship under which they have legal rights. And we'd suggest that in the absence of an enforceable non-compete agreement, they can't prevail on that claim as well. And that was another thing that Mr. Muldowney was asked below by the trial court, was essentially, if I find that Tamala applies, if I find that there's not an enforceable non-compete agreement, does that dispose of all 3 counts, which would include the 2 tortious interference counts? And he acknowledged that it would. And so there was no error by the trial court in granting summary judgment with respect to those claims as well. To talk a little bit about Tamala and the reason that I think Tamala was correctly decided and why this court, I believe, should follow Tamala. What you had in Tamala was a doctor who signed a non-compete agreement, and then that agreement was attempted to be enforced against him. And the issue there, similar to what we've been talking about here, was referral sources. And what the court found was that a relationship with a referral source is not a protected, legitimate business interest. And it based it primarily on the plain language in the statute. And we talked about it before, substantial relationships, specific, prospective, or existing customer, client, or patient. It relied on the Sanal case, and I think rightfully so. It wasn't bootstrapping. I mean, what Sanal said, there it wasn't referral sources. There it was someone trying to enforce a non-compete with respect to all prospective patients within the geographic area. And what Sanal said is that you can't protect a relationship with unidentified patients. It has to be specific patients is what the statute says. And so you need a specific prospective patient you're talking about. That was Sanal. And then in Tamala, what the group there tried to do was take the losing argument in Sanal one step further to say that somehow a relationship with a referral source could be protected, even though the referral source is providing, and this is what Tamala said, a stream of unidentified patients. Well, if the relationship with the unknown prospective patient can't be protected, then how can you protect one step removed from that, which is the referral source who provides that unidentified stream of patients? With respect to the Smith-Kline versus Beecham case, which Mr. Muldowney had referenced, and that's obviously a United States Supreme Court case interpreting the Fair Labor Standards Act, we'd suggest that it really has no applicability to this case. It obviously doesn't address anything to do with Florida's non-compete statute. To the extent that there's an argument by analogy, we'd submit that the analysis in that case, on general terms, would support the analysis that we're suggesting the court needs to engage in here, which is to look at the plain language in the statute and apply that within the context of this specialized industry. What the Supreme Court did in Smith-Kline-Beecham was they looked at the language in the FLSA, and they had to find out or determine whether or not this person who was not making a traditional sale but was getting commitments of sorts from folks, whether that constituted a sale. They looked at the plain language of the statute and said that sale was defined very broadly. It was any sale, there were a number of other words, and then it ended with other disposition. And what the court hung its hat on was this broad language in the statute, and that an other disposition could be more than simply a traditional sale. And what we're suggesting in this case is when you look at the specific language in the Florida statute, it cuts in our favor, not in theirs. There's not broad general language that protects all sorts of relationships. It's very specific, substantial, specific relationships. And especially in this highly regulated industry that I talked about, it would be improper to say that companies like this could have these substantial relationships because it would simply violate the law. Unless there are any other questions, we'd submit that for the reasons I've stated today, for the reasons that are in our brief, we would ask the court to affirm the trial court's decision. If the court were inclined to decide that referral sources were somehow protectable, we'd suggest that the proper posture at that point would be to remand to have the court decide whether any of those relationships were substantial in this case. Thank you.
Thank you.
Very
We
much
have
time
about
left.
3 minutes and 15 seconds left.
Thank you very much. Your Honors, Mr. Potter brought up the issue of looking at the statutory language, and to talk about the Florida statute, if you look at the statutory language, where 542.335 talks about the legitimate business interests that are protected and lists 5 of them. But the statute says that legitimate business interests include but are not limited to. So those listings are examples only. And that's one of the areas where we believe that the Tamala case was incorrectly decided, because this relationship is recognized even by the Tamala court as being a substantial business relationship.
Does the legislature, by the use of specific language in subparagraph or subpoint 3, substantial relations with specific prospective or existing customers, suggest that that preempts that part of the field, so that include, that is not limited, doesn't mean unknown relationship with unknown customers and the like? By using some specific language, how do they kind of define the nature of the field that we're to look at?
I think, Your Honor, I would agree with you on that, but the issue is the relationship we're looking at is not that customer relationship. We're looking at this referring relationship, which is a specific identifiable relationship, which, again, as we cite in our brief, is been addressed by a number of courts as being akin to a customer or client relationship. And as a result, that is a type of relationship much like the existing customer relationship. So to the extent we look at that provision of the statute, that's an example. Then a like relationship, which would be this relationship.
When you have a customer, usually there's an exchange of consideration. The customer buys a product. Here, the referral source doesn't buy a product, is not compensated, doesn't provide the product. It's on neither end of the commercial transaction. So are we trying to fit in a referral source as a customer by taking the commerce part out?
Well, Your Honor,
by akin?
I think that's where, again, the analogy to the Christopher case, again, it is not a complete analogy because obviously it's a different statute. But that type of relationship is a sales relationship in the sense of, as Mr. Potter mentioned, patients do have choice. If a patient wants to use another home health agency, they can. But there's nothing in the record that would suggest that, and I think it's a matter of common sense, that if a doctor refers somebody to a particular agency, more likely than not, and in most cases, that agency is going to be the one that the patient uses. And it's very similar to, in the Christopher case, prescriptions. I mean, if a doctor prescribes one company's type of medication, the patient conceivably could say, well, I really would prefer to have another company's. So, but more likely than not, if the doctor says, I want you to take this medication, they're going to take that medication. Same thing here. It's just a natural progression here. And again, as a matter of common sense and in logic, this has to be a significant interest, because all our clients have these marketing reps who go out and meet these doctors. And if this was not such a valuable relationship, the record shows that when Ms. Sprow went to Nurse on Call, they agreed to indemnify her in connection with any claim that might come against her in connection with the non-compete. So if this was just an entry-level, not significant person to be involved with, they would not be having that kind of a guarantee for them. And so that has.
You should wrap up, Silence. You got a little bit longer.
I will. But again, we just would say that's the relationship in that connection. On Kentucky law, I'd like to just, if I could, just say the choice of law provision is under case law, Florida case law, is controlling, unless there's a showing that there's a violation of a strong public policy. There's been no evidence in the record. We'd argue none of the arguments that were advanced by the appellees in any way show that there's any strong public policy that would be impacted here. And as to the issue of Kentucky being more favorable to employees, there's no argument that Ms. Sprow is somehow being restricted, is being excluded from making a living by the very narrow restrictions we have. And
That
thank
will
you,
do.
Your Honor.
Thank you.
Appreciate it.
Thank you both.